got thousands and thousands of dollars that he was not entitled to. If Liberty Mutual had sued him, they'd have gotten summary judgment. Our defense was he didn't commit fraud. Why do you think that might have been? Yeah, it was a simple mistake. He was asked a question. He misunderstood the question because of the way that his lawyer had explained the system to him. He gave a false statement, but there was no intent to defraud the insurance company. He thought he was giving an honest answer. If the facts, at least at first blush, point to your client being guilty, but there are issues you're going to need the jury to consider, now is the time to start planting those seeds. You can't be afraid. In my case, I could not be afraid of the fact that my client received about $25,000 that the law said that he was not entitled to receive. If I had tried to hide from that, we'd have been toast. Some things that I've found when we're talking about the presumption of innocence, some things that I've found that jurors tend to respond pretty powerfully to is when I stand in front of them and I tell them point blank, if I could prove to your satisfaction that my client was not guilty, we wouldn't be here. And I let that hang for a minute. If there was no evidence that pointed to my client potentially being guilty, we wouldn't be here. So what came to your mind when I said that? Okay. In, I would say, probably 99% of the cases I've tried, both of these statements are 100% true. We wouldn't be there if there wasn't some evidence suggesting that your client was guilty, and you wouldn't be there if you could if you could affirmatively convince the prosecutor of their innocence. Y'all wouldn't be in a jury trial, right? One of the things to remember, and I've struggled with ways to get jurors to realize this, you're about to ask a dozen laymen to analyze a case in a way that they are completely unfamiliar with analyzing problems. If they think their kids have done something, the first thing they're going to do is go to the kid and ask them, hey, what happened? And they're going to start judging credibility. Then they may talk to some of the other witnesses. Then they may go back to the kid. And at the end of the day, depending on how serious it is, I know I'm often fully willing to punish my children, even if I'm not convinced beyond a reasonable doubt that they did what I think they did. Right? In order to get jurors to not apply the rules that they apply at home when they're deciding whether or not to punish a kid, or to get teachers not to apply the same set of rules they apply in their classroom when deciding to punish somebody, you've got to be open and frank with them about the fact that we're about to ask you to engage in a mental exercise that is different than the way that you're used to solving problems. What I have found is that with these two statements in particular, I get a lot of surprised looks from jurors that basically tell me, wow, I can't believe that guy just said that. That is one of the best ways to build trust with a jury that I've found, is to say something that they are literally surprised to hear the defense lawyer say. My theory on why that is because this is a form of brutal honesty. I wouldn't be standing here in front of you if I could prove that this guy was innocent, and I wouldn't be standing here in front of you if there was no evidence that he might have been guilty. Sort of the other side of this is, don't be afraid to ask the jury direct questions that you might be afraid of the answers that they could give you. And when somebody does give you a bad answer, I couldn't find the picture of Kevin Bacon from Animal House that wasn't too grainy to go up on there. When somebody gives you a bad answer, thank them and then ask for more. Thank you, sir, may I have another? Thank you. Who agrees? How many of you agree with this guy? At the end of the day, almost every single criminal trial, you need to know whether every juror on that jury could look at a set of facts, believe that this guy probably committed this crime, and still find him not guilty. How many of you have asked this question or something almost exactly like it in Voir? Okay, I see a few hands. How many of you, the idea of asking this question in front of the guys who are going to decide your client's fate kind of scares the crap out of you? Yeah, because I know that when I look at this question, my gut tells me, holy crap, you're conceding that he's guilty. Why on earth would you do that? Is anything in that question actually conceding that he's guilty? No, of course not. Has anybody ever seen a criminal case where the evidence didn't at least meet a preponderance standard by the time it was all said and done that went to a jury trial? Okay, I see one hand, two hands. No, you wouldn't be there if there wasn't some fairly strong evidence that was at least enough to convince the prosecutor and the cops that your guy did it. So, ultimately, you need 12 people who can look at a set of evidence, find that your guy probably did it, but they haven't proven it beyond a reasonable doubt, and so they're willing to find him not guilty anyway. This is one where you have to read the room. I haven't asked this exact question in every voir dire, but I twist my way around to it. You have to twist your way around to it at some point in almost every voir dire on a criminal case. Scary is good. The more scared you are to ask a question, the more you probably need to just go ahead and ask that question. Let me ask you this. And I'm actually asking you guys, I'm looking for a response here. What's the worst thing that you could foresee happening if you ask that question? Okay, somebody may say, yeah, I could do that. And at least then, you've got something that you can start judging whether you believe him or not, right? Yes, sir.
I think the worst thing is that the jury's going to believe you do think.
All right, that's the scary thing about that question, right? If you have already conceded that if there was no evidence suggesting that he was guilty, we wouldn't be here, and have a brief conversation about that and what that makes them think when they hear that, and you've told them, I'm not going to be able to prove to your satisfaction that my client is innocent, is that going to be a problem for you? And you have a conversation. And then you get to the question of, and you may even preface it with, you remember a minute ago, I told you we wouldn't be standing here if there wasn't some evidence suggesting that he might be guilty. So what happens if you get to the end of the case and you think he probably did it, but you're not convinced beyond a reasonable doubt? Can you find that guy not guilty, even though you think he probably did it? You can't control what they're going to think, but you need to know what they're thinking. And the more you can get in their face politely and respectfully and jar some emotional reactions out of them, the better you can judge. When you ask that question, there will be some people on your panel that are going to go, oh, okay, he knows he's guilty. That's what you're looking for. Those are the people who need to go eat lunch on their own, right? The scariest answers you can get are the answers that you really need to get. Do you really think that no one on the jury panel assumes that your client is guilty because he's sitting in the room? Do you really think that nobody in the room is going to believe a cop because he wears a shiny badge and a big gun and carries a stick? And actually, that's my next slide. You can't poison the well because the well is already poisoned. You can't poison the well because the well is already poisoned. You just need to figure out where the poison is and get as much of it off your panel as you can. That's why the stuff that scares you the most, that's a big red flag that, folks, you need to talk about this stuff. I think the biggest problem that I had in voir dire when I was a young lawyer was the desire to teach. I want to teach these people new things so that they will see the world my way. And it took me a while and getting old to realize that shit doesn't happen. You're not going to change someone's mind in the 30 minutes that you're talking to them. So on finer points of law, you can explain how, okay, most people think that this is how the law works. Here's how it actually works. That sort of teaching you might be able to do. But on the broader scale teaching of, do you think cops lie? Do you think cops are honest? Do you think cops ever arrest people when they're not sure whether they're guilty or not? Do you think defendants ever get charged with crimes they didn't commit? Those sorts of things, people's attitudes are set. And the older they are, the more likely they are to be completely set and unchangeable. If you approach voir dire with a mind to getting people to change their mind so that your jury will do what you want them to do, you're cooked. The real purpose of voir dire is to get people to say all these terrible, venomous things about you and your clients and police and the government and all that stuff so you know where they are so that you can use your strikes appropriately. You're not going to change minds. Now, one thing you can do, and we're going to talk about this a little bit, is you can occasionally and by degrees change perspectives so that things they already believe help you instead of being an impediment to you. And that's something we're going to get to in a minute. If you've ever shied away from a question because you're worried that one asshole is going to poison the whole well, stop. That well is already poisoned. You need that one asshole to make it safe for all the other assholes to out themselves. That's what it comes down to. So, as Kevin Bacon once said in Animal House, when somebody hits you with a bad answer, your response is, "Thank you, sir, may I have another?" All right, thank you. Thank you. Who else agrees? Who else agrees? When you handle bad answers that way, you do three things all at once. Number one, you have communicated to the entire jury that if you say something that is clearly bad for me as a defense lawyer, I'm not going to try to talk you out of it. I'm not going to jump on you for it, and I'm going to take your answer politely and respectfully. All of the jury will like that. Number two, they have now made it safe for all the other assholes to out themselves because they're not the pioneer, right? And number three, the more people that say, "Yes, I agree. Yes, I agree," the people who disagree, that will steal their resolve. That, no, that guy is wrong, she's wrong, he's wrong, sir, you're right. That's how you begin to build your team. And at the end of the process, you know who you need to get rid of, and the people who have said, "No, I disagree, that's not right, that's not how we do things in this country," now very likely feel even more strongly in that way than they did before they walked into the room. So when you ask for a bad answer and then you take it with grace and then bounce it back out to the rest of the panel, you do three very important things with 2 words. Thank you. Who else? To earn people's trust, and remember, you're not trying to earn their trust to the point that right here, right now, I could just tell you something and you would accept it as fact and never question it. You are trying to move them, you are trying to pull them towards trusting you from, "You're a defense lawyer and a shark and I can't believe a single word you say." How do we build trust? Well, number one is likability. If you like a person, you're a lot more likely to trust them. If you dislike them, you distrust them. It's evolutionary. It happens before we even realize that an analysis is being made. How many of us have ever dealt with somebody that I can't put my finger on it, but this guy rubs me the wrong way, and I feel that I am on alert anytime he's around? That's the same system that analyzes everything that we encounter before we even have an opportunity to realize that that analysis is being made. Those people are doing that with us. And so we are starting from a position of keep that guy away, he's dangerous, he's not trustworthy. And in 30 minutes, you have to at least get them to, "Oh, okay, I'll hear what he has to say." And then you got to continue building that trust throughout the trial by never lying and never being a dick. Those are your 2 jobs. Be honest, be friendly. When you're talking to people, be understanding. If somebody says something that you don't particularly like, don't jump on them for it. Again, most of the time, it's more helpful than it feels like. It may feel scary in the moment, but it's serving a purpose. Make surprising admissions. Most of my trial experience is in DWIs. And I tell jurors in almost every trial that now that I have children, if it were put to a vote, I would, without thinking about it, vote for a zero tolerance policy on drinking and driving. If our law said no alcohol plus car, I'd be cool with that. It's not what the law is, and that's why we're here. We've all agreed to live by the law, even if we don't agree with the law, but we're not here because I think drinking and driving is cool. You are never going to hear me try to justify drinking and driving or try to suggest that he deserves a pass because it wasn't that big a deal. We're here because there's a dispute about what the evidence means. And if the law was no drinking and driving whatsoever, this would be a much easier case. Instead, the legislature has given us something a lot more complicated that we're going to need to parse through. When I talked a minute ago about I can't prove that he's innocent, and if there was no evidence pointing to his guilt, we wouldn't be here. Surprising admissions get the jury's attention and convey to them, all right, this guy's not going to play games with me. He's not hiding behind something. He's not hiding behind the law. He's shooting me straight. I can probably take what he says to heart. Here's another one that I love, 3823. To my knowledge, we're the only state in the country that allows juries to decide suppression issues. The problem is, you're asking jurors to unring a bell. If you get to a 3823 instruction, you are dealing with jurors who have seen evidence that you're going to ask them to disregard. So you got to ask them point blank, can you ignore evidence that you've already seen, even if it means acquitting a person that you are 100% sure is guilty? And just kind of let that hang there. Different judges will allow you different amounts of leeway in a hypothetical example to use.